Maneva na sema PENDREAM TV. PENDREAM TV de osia dem yopo.
On the 1st of August to 30th September, a legal vacation, Emma a judicial staff. Name Chief Justice Atta said there are some cases regardless of the vacation no. On better so add ye and some no and I say add the asem no. And no and attaching ya or represent a Duboahim. Godfred Dame, ya or represent Abdul Hanan, if I am right. Any afin so no. Other cases are Akka. Ya or more protesters say, Adenti, and even on legal vacation, crown court, a person eternal say, a DISA assembly. And no, and a Ghana Bar Association president, and as a GBA president, and also Edo Nanua Tuma, Deputy Attorney General, a fire a GBA president, attaching Godfred Dame, and afin so no one will protesters say, or more a legal vacation, and intino, or more court. And may represent say our client. Hi, PENDREAM TV. Subscribe to the channel, bell notification, no, na share ma afofro and sa and can be comment section. One of the padrinche aba. Yenti the details of this story.
Over directives compelling lawyers to appear in court during the vacation period, despite indicating their unavailability. The GBA says the legal vacation, which runs from August 1 to September 30th, is intended to provide judges, lawyers, and judicial staff with a period of respite following the demanding court calendar. Now, let's bring you a bit more from what the GBA's letter to the Chief Justice. And then we also know that the Deputy Attorney General has responded to the GBA. So take us through what we have so far.
Right. So first is the open, I don't want to call it an open letter. It's a letter directed to the Chief Justice. And then we're seeing a response as well from the Deputy Attorney General.
Right.
The first from the GBA pretty much backs up what has been petitions, open petitions, which we have learnt of in the media as well in relation to vacation courts having to hear high-profile cases, and not just in terms of certain applications or interlocutory matters, but full-blown trial, pretty much, right? So the GBA's letter is dated the 10th of August and is signed by the national president, Godfred, and they are pretty much, like I've been telling you, backing the petition from the three law firms, Zoe Kyea and Co. That is Simon Atachia's law firm, who is representing the chair, the Ashanti Regional Chair of the NPP, as well as a Signals Bureau. Kwabena Duboahim, he's representing it. Then there is Dame and Partners as well, the former Attorney General, who is also playing a critical role in the Abdul Hanan Aludiba trial, and then Sam Okujeto and associates as well. They as well, it appears, have pending cases at the court, which their judges have been assigned as vacation court judges, and the judges have given indication that, look, we will proceed with our own trial because we're sitting as vacation court judges. And that's become the subject matter of a conversation, because the lawyers of these three firms say that it's a legal vacation. That's where we catch some break as lawyers. And so asking us to come before you as lawyers on behalf of our clients is something that we cannot do. When you call the cases, we will not be present in court. And so we will not be present, and so postpone or adjourn, right? Now, the GBA is backing that against the warrants directing judges to continue part-head criminal trials during vacation. Now, they seek to cite some legal authority with respect to why they are making the argument. CI 47, in direct relation to the High Court's rules, says that the rules which guide the operations of the High Court allows for 3 vacations, and the longest of which is 1st August to the 30th of September, which is presumed as a legal vacation. And they argue that vacation court, whether physical or virtual, are meant only for emergencies and never trials. Is the argument being put forth by the Ghana Bar Association. They also argue that lawyers cannot be compelled to appear during vacation and courts cannot proceed if counsel are not available. This is one part of their statement or the letter I want us to take a lot of or attach a lot of importance to. Now, they say that lawyers cannot be compelled to appear before the courts, and same, the courts cannot proceed if the counsel is not available, right? I'm asking us to pay attention to it because we'll see in that response from the Deputy Attorney General why this becomes a subject matter of debate. Now, they want that pushing ahead will smack of a bias or selective justice. That deciding to proceed with the hearings will, amongst many other things, suggest that the wheels of justice is being tilted towards a particular direction, at least in perception-wise, right? Now, they say that they close a statement by saying that they are confident the petitions will be considered favorably and urge the judiciary to respect vacation traditions. That's the argument that's been put forth by one of the one of the lawyer groups, right? Because now we know that there's another group that exists. But here's what the Deputy Attorney General has been saying with respect to a response to that by the Ghana Bar Association. They say that contrary to the GBA president's claim, the power to decide whether to take proceedings on the substance of a case during a legal vacation is for the bench and not for the bar, right? Because of the argument that had been made is that the court cannot proceed without the counsel. Well, the Deputy Attorney General says that that claim cannot be true because it is the bench who determine if a case should proceed or not, and not the lawyers who will be making an argument like that. And so if the judges are saying that we are proceeding with a case, that is what must happen. What other arguments does he make, right? He further argues as this has always been in the case of Ghana too, citing reference to what happens in the English courts, where he says that is where the tradition of legal vacation emanates from. He cites an example and provides basis in the law as to what happens during the vacation trials, that vacation judges can sit on their own cases because they are pretty much the lords of the trial and can hear it to its end. But with respect to cases of other judges, they can only hear interlocutory matters. And he argues that that is the case in Ghana too, that as we have known it, it is the Chief Justice who determines when and where a court should work. She may, as we have come to know it, upon a warrant, determine and direct that a judge sits even on weekends. And that is what we've become very known to. Now, they proceed to, the Deputy Attorney General proceeds to say that what the GBA president proposes in their letter to the Chief Justice seeks to, what they're seeking to do is grave. It seeks to move the power to manage and control court proceedings and to do justice from the hands of the judge into the hands of a lawyer. Remember the statement which says that you cannot compel a lawyer to appear before the court and you cannot proceed without counsel being present. The Deputy AG argues that that proposition is grave. Why is he saying that? He says that if that were the case, justice delivery or the power to manage and control court proceedings, which happens within the judiciary, is being moved from the hands of the independent arbiter, the judge, into the hands of a party in a litigation, which is the lawyer. And further argues as this has severe and far-reaching policy implication for justice administration in the country. That is the argument of the Deputy Attorney General. Now, he says that a lawyer who wishes to take a rest during legal vacation knows exactly what to do. What must they do? We'll seek to find out when we're joined on the phone pretty shortly as well. He attends proceedings and makes a plea to the judge for accommodation. The judge will in turn consider the plea and in the interest of justice either grants the request or refuse it altogether. So the argument the Deputy Chief Justice, the Deputy Attorney General, I beg your pardon, makes is that if you have an objection to a judge in a trial saying that I want to proceed even during the legal vacation, yours is not to be writing to the Chief Justice. You should go before the judge and make an application, a plea of some sort that consider, allow us take the vacation as well so we can attend to these pertinent matters later. And the judge will determine whether they will hear that plea or they will refuse it altogether. So that is the argument in disagreeing with the Ghana Bar Association by the Deputy Attorney General. Albert Kwashiga Esquire is a private legal practitioner and he's head of public law at the UPSA Law School. He's joining us via the phone lines this afternoon. Counsel, appreciate you for speaking to us. So the conversation for a lot of people is a matter of the right of lawyers, if we can call it a right, to go on vacation and justice delivery. But I'll come to you in a tad. Here's the Chief Justice, in his own words, reacting to the petitions and the conversations which have come up at a forum somewhere in the Bunu region. And then I want us to listen to him, and then I'll come to you in terms of a response.
To write to the Chief Justice to say that the cases should not be adjourned to the vacation. So I am not coming. I have already made agreements outside, so I'm not coming. You are a lawyer. You have your clients. If your clients decide to leave you leave, well, go on leave. But you cannot say that there's a legal vacation and the judge who is actually sitting cannot do your case. No, that's not it. And then adjournments are not at the instance of the Chief Justice. An adjournment is a judicial act. This is something that is so basic that sometimes when people write that I got a letter saying that I should withdraw the directive and also direct that the cases should be heard in the same time. I said, you went to court and the judge decided that she was granting you.
So that is the Chief Justice, Paul Bafo-Boni, his lordship. Counsel, on this matter, the Chief Justice appears to have made some comments in relation to it. Where does the pendulum swing between a right to a vacation and then justice being dispensed and done swiftly?
Thank you for the opportunity. Let me begin by saying that, like many of my friends, I love my vacation. I don't. It's a time when I rest a lot and I do other things which I am supposed to do. So I consider vacations as very, very important. And I believe it's important to a lot of lawyers. The lawyer's work is very demanding. And so if you have the opportunity to rest, I believe most lawyers will take that opportunity. Now you ask me where the pendulum swings. I cannot tell you where the pendulum swings. I can express my honest views on what I think should be the position. Okay.
Right. Now
you refer to some provisions in the rules of courts, CI 47 of 2004. You refer to Order 79. You may even refer to Order 80. You refer to Order 82. I mean, the issue of vacations, if you look at those orders that I've referred to, I'm not really in doubt. Okay. Now, I begin first by even asking you to look at the ordinary meaning of vacation. If you check any, dictionary, the lexicon meaning tells you what vacation is. Okay, it's a time period where people spend time away from work to rest. There's no other way to look at what vacation means than what I've just said, which is coming from ordinary lexicon meaning or dictionary meaning.
Right.
Okay. So during vacation, you don't expect people to be working, or even if they have to work, they have to do light work, not heavy work. Okay. Now, so we have to look at all this within the context of the power of the Chief Justice as well. don't forget that if you look at the same rules book, and look at order 7 to 9, rule 1, right? Rule 1, sub 1. It tells you that subject to the Court Act 1993, as amended, the Chief Justice may appoint any day, including vacations, for the hearing of causes or matters as circumstances require. So it does not distinguish the causes. So it can be an ordinary application, and it may even be what? A substantive hearing of a matter during the vacation. Now, if you reconcile this, with the other provisions in the CI 47, and you look at the constant mention of vacation, I think that the established practice over the period has been that, during the period of August to September, no serious work is done in the court. When I say no serious work, I don't mean no serious work, but basically applications are taken and not substantive hearings. So, for instance, if there were a trial, most courts, for instance, or all of them are expected probably put it during term when the courts are in session. Now, I use the word term, and the CI defines what term is, TERM. And listen to what the law says. It says term means any period between vacations when the High Court is in session. So if these are during vacation, the High Court is not in session. But you have to look at this in the light of the Chief Justice's power. So it's kind of a balance that we have to draw.
Right.
And not to be a bit insistent, because this is what it is. The right to a lawyer before, during, and probably even at judgment is very, very important.
Right.
Typically, let me give a typical example of the situation. Look, when, 2 days ago, a friend went to the outskirts to do the case. And what happened? But for the presence of the lawyer, something terrible would have happened.
Right.
Another typical example, somebody is in custody at this particular time because for one or two reasons, a lawyer could not appear in court on the particular day when the case was called. And if the lawyer was there, the case would have been different.
So counsel...
So the presence of a lawyer before a case is heard is very, very important. So if a lawyer... Yes.
Doesn't that flow in the argument that the Chief Justice makes, for instance, that your responsibility is to your clients? Because we've seen the lawyers in these respective law firms make a very bold statement that, look, we are on vacation. If you call the cases, we will not be present. And so adjourn until after the vacation. Are they not putting their clients in harm's way based on what it is that you are telling us? And even the argument that's been made that their duty is to their clients and not necessarily to the court.
No, let me tell you one thing. If you go to law school and you do advocacy, your duty is not only to your clients, you have a duty to the court as well.
Right.
So lawyers are officers of the court. Okay? So that is what it is. Their duty is not only to the client, it's also to the court as well. And you can check that. So the point I'm making is that there should be a balance. Now, if a lawyer is not available, let me tell you one thing. We have to look at this within the light of the broader labor laws of the country. Assuming that the lawyers who are defending particular persons involved in certain cases decide that they are taking an annual leave from their private law practice, have you forced them to appear in court in the circumstances? So we have to look at this in a way. There are many laws that come together for us to operate the governance system. Let's not make it look like, the lawyer must always be there. That's the point I'm making.
Right, but what we have right now, it suggests a stalemate of some sort because the positions are not changing. What possibly do you foresee happening when these cases are called, the lawyers insist they're on vacation, and things play out the way it's expected to play out as we have it now?
So this is what is going to happen. Now, the court insists that it will go on with the cases. Okay, we'll go on with the hearing, for instance. So what it means is that when the case is called and the lawyer is not there, the court will proceed. In which case, the client might be required to conduct the case by himself, when in fact the client has chosen right from the onset to be defended by a lawyer. Don't we create a very troubling situation, for instance? Right. So, I mean, my honest view on this matter is that if the lawyers are saying that they are not going to be available during the vacation, I mean, we'll come back to 10 in October. The court can decide to hear these cases on daily basis or even any other day. That can also expedite the trial. Right. But as far as I see, I'm just imagining myself in a position where the court insists that I have to appear in a court of law when I feel that I have to be rested. That's what vacation is for. And the rules have used vacation about 4 or 5 times. Check the meaning of vacation. Indicating from the ordinary lexical perspective. People should take rest in the circumstances. So I do not think that, I mean, we should force the lawyers to come. In any case, if the judiciary, if we are able to be convinced, for instance, I'm willing to be convinced if I see other cases which are not high-profile cases or political cases being fit for hearing during the vacation. For instance, you have other cases that are going to be heard, not only high-profile political cases. I'll be convinced. Then the issue of equality before the law and all those things are being dealt with. But when I see a situation where only high-profile political cases are going to be heard within the period, I mean, it raises a lot of concerns. And I think that, I mean, we don't lose anything when we allow the rules to play out the way they play out all the time.
Right. Counsel, I appreciate you speaking to us this afternoon. That's Albert Kwashiga, is head of public law at the UPSA Law School and also a private legal practitioner. I'm sure it's a debate. We'll see how things will roll or unfold when the hearings do begin. But for now, we can still stay in the courts for you, Kemini.
PENDREAM TV. Now, so far so good. Say open online portal Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.